Very good evening to all of you. I am Manya Khanna and welcome you all from on behalf of the Karuna Mediation and Arbitration Institute, and I am the Operation and Corporate Relation Associate here. So basically, Karuna Mediation and Arbitration Institute vision is to spread about the awareness about the mediation for resolving disputes with compassion and empathy. Further, Karuna also imparts training to the students, lawyers who all are interested in ADR programs, arbitration mediation, and to learn them the techniques of what is mediation and use them in resolving disputes, how to disputes in conflicting parties. And we also welcome Shulini University of Legal Science as our knowledge partner, which is established in 2009 in Solan, Himachal Pradesh, is recognized by NAC, and it is under the top 200 global universities as per the Impact Rankings 2022. Shulini universities provide various other undergraduate and graduate postgraduate programs, except law, in pharmacy, engineering, management courses, and various others. So, in progress toward our this vision, we will be organizing related this webinars to spread awareness about mediation for students, professionals, whoever will be the future building blocks for this sector. So today's webinar will be on mediation and how you can become mediator. To impart and share knowledge about today's topic, our guest speaker, Ma'am Amita Sehgal Mathur, will be throw light to understand what mediation is and how one can be the mediator to successfully solve disputes. Ms. Amita Mathur ma'am has extensive experience in litigation matters in various fields related to matrimonial cases, intellectual property cases, contract laws, family laws, and many more other. And she has also been continuously in arbitration and mediation also, and has received training from University of Ottawa and registered being as the in Delhi High Court as a in mediation center as a trained mediator. She also been a mediator trainer in various mediation trainings. She practices before the Supreme Court of India and Delhi High Court also, is a member of Delhi High Court Bar Association. Ma'am also been associated with as a partner with Mathur and Associates in Delhi. So it's a pleasure, ma'am, to have you. And before proceeding further, I request everyone to please mute yourself within the particular event. And if you have any doubts or any questions, you may write up in the chat box. We can take up further in the end of the particular event. So I request ma'am to please share us with your insights on this particular topic. And good evening, ma'am. Good evening, everyone.
Good evening, Manya. Thank you so much. And good evening to all of you. How many of you here from which university? I may know. But most of the people here are lawyers or law students.
They both are from law, so also law students also and lawyers also.
Okay.
Some of them are experienced also in mediation.
In mediation. Okay. Okay. Great. So thanks, Manya.
Thank you.
Well, yes. So as Manya just said, yes, I've been introduced to this field of, I would say, alternative dispute resolution or mediation, and been practicing now as a mediator since quite a few years, since more than 10 years. So as the name suggests, as I would start, why is it I can't see people here, Manya?
Okay, yeah, I request everyone to,
if who I'm talking to. It's nice, right?
Yeah, okay.
That's, if I would say, one of the very key aspects of mediation is that, communication. So you are able to communicate better, if not physically. The second best thing is that at least I'm able to see who I'm talking to or who I'm addressing.
Yeah, sure. Everyone, if possible, then please switch on your cameras. It will be a good interactive session then only, as the topic suggests evenly. Yes, I understand that nobody in this condition, but some of you can open the cameras if possible.
The session, I think, becomes lively only if, you know, see, if I turn off my camera and I speak, does it sound, you just hear a voice, you don't know who the person is, right? It doesn't sound as good. That's okay. You may be sitting in your homes. That's okay. That's all right.
Yeah, finally, one participant has on the camera.
It'll be nice for all of you. See, I've also been a student at some time, and when you are participating or you're hearing something like this, it's good if it's a conversation and discussion, right? Nobody wants to hear lectures and speeches and preachy sessions. So if you're being introduced to a concept, especially if most of you are law students or lawyers, it would be nice if you get an insight into it and it makes you keen to know more about it, right? At least by the end of this session, you should be able to reach a point where you say that, okay, what a process this is, and we want to know more about it, right? That would be the part. But I don't know, for reasons best known to everybody, they, everybody wants to keep their identities very confidential, though the proceedings are confidential. But anyways, so yes, let's begin. I hope slowly and gradually we'll see more people.
Sure,
So as I said, that we call this alternative dispute resolution. What, as the name suggests itself, why do we call it alternative? What is it an alternative to? Does somebody know that? Why is it called an alternative? Alternative is the second option. So what is,
Alternative to the litigation we usually
sorry, you need to be a little louder, dear.
Ma'am, alternative to the case proceedings and the litigation we usually prefer.
Yes, that's very good. So that's what I'm coming to. See, conflicts, or if I may say, what is a conflict? Or if I may say, differences between any two people, differences between two sisters, two brothers, a brother and sister, they're all part of our lives, right? When differences escalate, they may escalate into a conflict. When they get magnified, when they get into a series of actions and reactions, they become a conflict, right? Now, while we can't eliminate conflict in our lives, we can always find better ways. I have a difficulty with the term alternative, but let's accept it for now, because the usual norm has become that whenever there is a difference between two people, it is deemed that, oh, we have become rivals, right? It could be a difference on any point, on any issue, even on any political issue, on any issue regarding a society, issue regarding religion. The moment two people have differences, they perceive it that, oh, now we are, we have a conflict between each other and we are opposed to each other, right? Now, when we talk about this in the scenario that we are talking, as you said, that, it's a court proceeding. So what happens between two people who are in a conflict, like it's a property dispute between two people, between two brothers, right? Or there's a property, or there's a tenant landlord dispute. So what happens is that the first recourse that a person would take is, okay, let's take it to the court. I will take you to the court. That has become the norm. Now, as opposed to that, this mediation is a process which has evolved over a period of time as an alternative dispute mechanism, though, as I said, it is the best mechanism, best dispute resolution mechanism for reasons that I will convey to you. What is mediation? Anybody has an idea? Anybody could tell me how they perceive mediation? What is mediation all about? Can I?
Mediation is a process where we resolve disputes outside the court.
Sorry, just be a little louder. Where you resolve disputes?
Outside the court. It's an informal process in which we resolve the disputes outside the court.
Yes, absolutely. That's very much a part of it. That's a very good attempt. You try to resolve the disputes outside the court. Yes. So mediation is going on the lines on which, what's your name? What's your good name?
Abhishek Krishnan.
Abhishek. So as Abhishek said, that when we go to the court, what are we doing? The two parties, through their lawyers or on their own, go to the court and say, here is my case, here is the law, please decide on the basis of law who is the winner and who is the loser. Right? So as we call the court process an adjudicatory process, there is a judge before which the parties appear, and the judge decides and has to decide that amongst the two, who has a good case on law and on facts. As I said, like in a property dispute between two brothers, there could be one brother who goes to the court and say, oh, this was, this property my father has left behind to me. Here is a will. He shows the will to the court. The other brother says, no, my father loved me equally. He couldn't have left me out of the property. This will is forged, but the grounds in court are that he can only show that the will is forged and fabricated. Right? So only on grounds as prescribed. I'm giving you an example so that you're able to appreciate what is mediation and what is the advantage of mediation. So that brother can only go to court and say, sorry, this will is forged and fabricated. There are certain grounds in the Indian Succession Act which lay down that you can only challenge the will on certain grounds. If he can succeed, he will win. Or if he can't succeed, the other brother will win and he will lose. And the one loses, again goes to the court higher than that, and then another court. So 3 rounds of litigation. And as we know in our country, because there are a number of cases that the judiciary is burdened with, so the cases take about 15 to 20 years. I'm also saying on the minimum side. Usually it's said that, people are hardly able to see their litigations come to an end, especially property litigations come to an end during their lifetime. That's unfortunate, but that's the way it is. But the time is not the reason. What I'm trying to tell you, the purpose is that the grounds on which it can be challenged are limited and only one person comes out as a winner. As opposed to that, what is mediation? Mediation is a process whereby two parties are attempting through a neutral, impartial third person who is a mediator to come to a mutually acceptable settlement. Now, as the definition sounds very harmonious and very nice, right? But the whole challenge is how can that be done? Two parties, a person who is, even when I heard about mediation first, I said, how is it possible? Two parties who can't see face to face with each other, how can they be sitting and finding a mutually acceptable solution? Right? Now that's where the training, the role and skills of a mediator come in. And the power of the process of mediation. Mediation is not a compromise. Mediation is not finding any kind of midway. Mediation is where, as a mediator, you are facilitating. The word to be emphasized here is facilitating communication between two opposing parties to come and sit across the table, talk about their disputes, first vent out their disputes, listen to them together, listen to them separately, understand the conflict, what is the problem which is surfacing on the face, and what are the problems which are underlying, right, which never come on the surface and which can never come up in the court, right? Like I said, the dispute between two brothers in court, the brother can't say, oh, I'm very sad, my father was equally loving to me and my children. But when they sit across in mediation and they talk to a mediator or they talk to the other side, and we've seen it happening before us, the parties break down. That underlying concern is, yes, of course, the property, but a lot of other things. That I was relying on my brother. My brother was my support. He was my elder brother, right? He's not able to accept that his relationship with his brother is breaking down. As ideal as it may sound, but it happens. And this can happen only when the mediator is able to create that environment where he is able to inspire that confidence between the parties that they can talk. So again, coming back to the definition of mediation, it is a process, it is a confidential process. Now, what would it mean? Anybody who knows about mediation, any lawyer here who knows about mediation, what would you mean by confidential proceedings? Anybody?
Whatever happens in the session remains between the parties and the mediator and the four walls. It does not go beyond that. So that is where the confidentiality.
Be a little louder, dear.
Okay. Am I audible at this?
Now, yes.
So when you say the confidentiality is maintained, whatever is being discussed or whatever information is being exchanged, everything is between the four walls of the room. It does not go beyond. And when parties want to take it up, it is accepted as a settlement agreement. There's not much of detail mentioned in the agreement. It's just that what is mentioned is put up, not what is being exchanged as part of the mediation session. Hence, the confidentiality is maintained.
Yes, very right, very right. You are Jharna.
Yes, Jharna.
Jharna. So as Jharna very rightly put it, this is a very, very essential part of mediation, right? Because when parties come in the first go, they're very skeptical. What if we say something and mediation doesn't work, and we go back to the court and all our, whatever facts and everything is just opened up. So as mediators, we need to, and we convey to the parties every time, there are two aspects of confidentiality. One, that as Jharna said, whatever happens in mediation stays there. If the mediation is successful and the parties are able to arrive at a settlement, then whatever terms of settlement are agreed upon, they are put down on paper and the parties sign on it, then it attains finality. Then nobody can wriggle out of it. It is binding in the court of law, right? But if for some reason the mediation is not successful and the parties need to go back to the court or they need to resort to court proceedings, then whatever happens or whatever discussions have happened in mediation cannot be relied upon, though nobody can record it or do anything, but none of it will be sent by the mediator to the court or can be relied upon by either party to the court to say कि mediation में तो उन्होंने ये कहा था, now he is taking a different stand. So that cannot be done. And what is the impact of it? The impact is that this gives confidence to the parties to open up completely. Only when they open up can the mediator help and reach the underlying interest of the parties and empower them. Please remember that why this process is so successful. Why the mediation process has of late become so successful with the parties. It's for the reason that the mediator is not deciding anything for the parties. The mediator is not judging the parties, who is right and who is wrong. The mediator is only facilitating. He is empowering the parties to take their own decisions instead of a third person like an honorable judge deciding for them. It is the self-determination that yes, okay, now these are my interests, as I told you, as in the example of a property dispute. Now when two brothers sit across the table in mediation, after of course a few sessions with the mediator, they see, okay, now the other brother also sees that, okay, this is the underlying interest. What is pinching the other brother is not just the property, it's something more. He needs that recognition. He needs that acknowledgement that he was also a precious child of the parent. He's not able to accept that his parent has completely left him out of everything. So these are the concerns which can be met only during a mediation process, and that leads the other party to come down from their hardened positions. When they go to the court, what do they say? मैं कोर्ट में देख लूंगा तुझे, मैं लड़ूंगा अच्छे से, मैं कोर्ट में देख लूंगा, मैं देखूंगा तो कैसे ले सकता है. So these are the hardened positions that they come with when they come to mediation. And then when the sessions happen, and then when they sit across, they are able to talk about a lot of other things. Like I said, these are the underlying interests. As I said in the example of property, it could be a landlord-tenant. There could be a tenant who has been paying, for years and years regularly to the landlord. Now you see the example of COVID. There could be, there is a tenant who has not been able to pay since the last 2 years. Now, if he goes to the court is not going to hear anything. But when they sit across for mediation, he's able to convey that I have a child who is in hospital, that I have all my finances I've run out of all my finances. So it's not that mediation is not about all emotions and sympathy, but it's about sensitizing the other person with the underlying concerns, where in this case, the landlord is also able to take an informed decision that, okay, yes, he has empathy, if not sympathy, that yes, he has a genuine problem. His intentions are not so bad. Okay, let's try and work out a settlement where if not now, you can pay me in a certain manner. You can pay me over a period of time. That's where I'll come to another very, very important aspect of mediation, that you can generate multiple options. It's not just one case, lost or won. No, you have multiple options. We see in matrimonial matters, we see in child custody cases, where if they go to the court will only see what are the pleadings. The court will not see that what the child needs. I mean, to a certain extent, as the time permits, courts do it. But when the parties come before the mediator, they are gradually, even in a contested, say, dispute between a husband and wife, where there is a child involved, and the one parent says, I will not let the child see the other parent. And over a few sessions of mediation, they understand that their disputes cannot be more than the interest of the child. So this is what mediation does. And then they themselves sit down and say, okay, this is option 1. We could do this. This is option 2. This is option 3. This option you don't get in court. And these decisions, because they take themselves, both the parties, they take themselves. It is very rare, though it does happen sometimes, it is very rare that they back out of it. So, as I would say, what the process does to you is that you go back, you're taking a voluntary decision to first attempt a mediation. It may not, the mediator doesn't have to do it with the goal in mind that this has to be settled. Let me tell you that with my experience. This should never be the endeavor that I have to settle this matter. What is important as a mediator now is that, yes, I need to follow the process to the core. I need to understand the conflict. I need to see the underlying reasons behind the conflict. I need to bring the bridge, become between the two parties. I need to facilitate communication between the two parties. Help them where they get stuck. Help them do a reality check. That, okay, what is it that you're looking for if you go to court? This shouldn't be done as a threat ever. But if you go to court, what is it that you may get? And today, since you are attempting mediation, what all are the options? You have to make the parties do all of that. And when they do all of that, and whatever decision they take, there are some parties who still say, right? There could be a case where a party is so hurt, they say that, no, I want that for the next 10 years, I want to see this person in court. Fair enough. Their destiny beyond a point. So mediators should never feel that, oh, it's because the matter has come to me, I need to settle it, and I will, it's, or judge one party, oh, this party is acting wrong, this party is acting unfair. No, it's ultimately their case, their destiny. As a mediator, you can guide them into certain direction within the framework of the mediation process. I always stress on it because it's very challenging and very important. And yes, when you talk about how to become a mediator, one, it's very important first to be a law graduate. The knowledge of law, domain knowledge of different aspects of law which come up in the disputes is extremely important, right? Now, if you have a case before you, which is, say, contractual in nature, and you don't have much knowledge of contract law, then you will not be rightly guiding. When I say guiding, I don't mean that you are judging or you are telling the parties who's right, who's wrong, but even to give them a reality check that, please check at your end, or please check with your counsel if what you're saying will sustain in law. There are ways in which we put it. Please check with your counsel if it sustains in law or not, right? So unless you have that knowledge, you can't guide any party or any lawyer further. So yes, the knowledge of law with some experience is very, very important, if not mandatory, let me put it, right? Because we are all still in the process of framing certain, there is an enactment also which may come very soon, and framing certain rules for mediation. So all that is also coming. But these are all, from my experience, I would say that these are the requirements, and that way you are performing your role to the best as a mediator. And then, of course, there is a training which is given by trained mediators by the Delhi High Court, and rest, so far as your organization is concerned, Manya would be able to guide you better. But this is how it goes so far as the mediation is concerned. And in the training, there are various aspects of the process of mediation which are taught to you through various ways by trainers, by doing role plays. We do role plays for parties, by giving you certain training material. And we have very senior mediators who've done, from Singapore, from US, who come down and who give and who share their experiences of different aspects of mediation. Like I said, communication, how to communicate, how to ask the right questions in mediation. As I just gave you an example, when you are giving a reality check, you can't tell a party, your case will not be sustainable in law. No. So how to ask the right questions, how to bring them towards their interests. What do you think you are looking at? What do you see at the end of this mediation? Or how do you see your relationship with your brother or sister or wife, whatever the case may be, right? Though there are all kinds of cases which come, there are IPR cases, contractual, and in every kind of case, there are relationships involved. So how to ask those right questions? Then we train on negotiation skills, a very, very important part of the mediation training. And when I talk about how to ask the right questions, we're always reminded of this very small example our senior always gives us. There is a mother who has 2 daughters, and she has only one orange. And both the daughters come to her and say, I want that orange. And I want it. Now, what would be the first reaction of the mother? Okay, let me cut it and give it to both of you. Right? The daughters say, no, I want the entire orange. And the kids could do that, right? A child could do that. He says, I want the entire orange. Now, what does the mother do? The mother asks each daughter, why do you need the orange? When I tell you about asking the right questions, it may seem very improbable, but a wise mother may ask, why do you need that orange? Now, one daughter comes up and says, I want the pulp because I want to make a juice out of it. Now, the other one says, I want the entire skin of it because I want to make a face mask out of it. Right? Now, is the problem solved? The problem is solved?
Yes, yes.
Did any of the child have to compromise?
No, no.
None of the daughters had to compromise, and the problem is also solved. Now, what did the mother do? Now, the first attempt could have been fighting. The both are fighting and crying with actions and counter reactions, and it could have magnified the daughter. Children stop talking to each other, and the fights magnify. But the mother, at the right time, asked the right question: why? Right? So that is what I'm stressing on. That is something that you will learn with training and experience, that at what time, at what stage of the mediation you ask the right questions. And that also plays a very important part in helping the parties to come to a decision themselves, because they come out with the real interests, right? And we see that happening all the time. I see somebody has here. Okay. Was this, you're confused where to start and what to do?
Yes, ma'am.
So you are a law student?
Ma'am, I have graduated as a law student.
You're a law graduate?
Yes, ma'am.
Okay. Have you worked yet with for some time or not?
No, ma'am, I have not started as a lawyer yet.
You're starting as a lawyer.
I have not started, but I have enrolled myself in the Uttarakhand Bars Association, but I have not started yet.
Okay. Okay. So you are saying you're confused as to what to do.
Yes, ma'am. From where to start if I have to work as a mediator and how to start?
See, as I said, if you think it really interests you, as I said that, for me, the process it's very, very interesting because it brings an end to the dispute and it gives a lot of satisfaction to the parties, which brings them back to me again, right? Because their dispute is resolved, they go back satisfied, their relationship is either restored or at least not worsened with the other side. So as a lawyer, I would say that the party always would come back to me and say that, this is how my dispute was resolved. That's what the party wants. They don't want to fight. They want to resolve the dispute. So if you think this process interests you that much, yes, you could, you could get your training as a mediator. Though there are some years of experience that you need. I can check that and let you know. But you can, start coming to court and seeing some mediations. Where are you based?
Ma'am, I am in Nainital right now.
Oh, you're in Nainital.
Yes, ma'am.
Okay, okay. So you intend to practice there or do whatever you want to do there only, or you would?
Ma'am, I want to start in the Nainital High Court.
Okay. Okay, so find out about, I'm sure there is a mediation there as well. There must be a mediation center there as well.
Okay, sure, ma'am. Thank you.
Yes. So any other queries from what I have conveyed? Because unless I know that what I'm conveying is being absorbed by all of you, only then I go further.
Ma'am, may I one question, please? Like
Yes.
you have said, like we can shadow the mediation cases or join the mediation cases in the court, like right? You say to Shreya, as a young mediator, if we want to learn skills, we can join the trainings, we can have role plays, everything. But being a young mediator, like if we have a training, we have been successful qualified as a mediator, how one can enrich their more experiences as a mediator? Because being a young mediator, no one will be able to give the cases to us like have a dispute, please solve this, you know. So how one can do and indulge that experience, or can join any other mediator, but it's a confidential process, so there is a clause thing. So any
See, Manya, so far in Delhi and in a lot of other states in most parts of India, only court annexed mediation is happening. When I say court annexed mediation, it's only mediation centers which are annexed to courts, to any high court or any lower court. Only that is recognized. Private mediations so far are not being recognized. Do you get what I'm saying? Like, I can't run so far a private practice and have two parties here appear before me. Whatever mediations I do because I am, part of the I'm panel mediators in the Delhi High Court, right? So now there I have received training, and it takes it. You have to have some patience. After you get trained, then maybe you could be allowed to work as a co-mediator, get some experience, and then you reach the stage of where you can be a mediator yourself, right? So that's how the steps go. But private mediation so far, that if you think that, you just do a mediation, training, and you can practice privately, that is not happening so far.
Okay. So basically, like if you are the mediator, so someone can join you as a co-mediator to learn the skills, to learn.
Only see, so far as the High Court is concerned, there is a center head.
Okay.
There is a, it is all managed by the Delhi High Court. There is a committee. There is a center head, the secretary, the organizing secretary of the mediation center. So whatever happens, has to happen as per her directions and her consent, as per the rules of Delhi High Court. When I'm talking about Delhi, right? So if somebody has received the first set of training, the first level of training, and then you apply to her, then if she deems fit, she could, give you some experience as a co-mediator. But just otherwise, you can't just go and sit in a mediation, because as you said, it's anyway a confidential proceeding. So it has to go through a certain process. And even otherwise, unless you know, as I said, unless you have some domain knowledge and you understand and you have received training in mediation, it doesn't make any sense to just go and sit there. You will be able to absorb the information only once you have received the training in mediation.
Okay. Yeah. Thank you, ma'am.
Yes. Yes. So let me know, Manya, if any queries from anybody, then we accordingly proceed.
Yes.
Because I have given an overview of now what mediation is and how the process goes and what are the advantages, how you could become a mediator. If there's any other query from your side or from anybody else's side, I'm okay to address it.
Yeah. Anyone can have any questions, then you can ask, please, or write it in the chat box. You can now unmute yourself and ask your questions. You may ask any questions like related to mediation, any question you have. Yes, Ritik, you have any questions? Okay, so anyone, any questions? You may ask, please. Or you may write in the chat box. It's totally your choice. Ma'am, we can give them 5 minutes to let them questions, or if they have any questions right
Okay.
now.
Fine, let me know.
Yes.
I'm here, otherwise we'll wind up. Okay.
Ma'am, I have one doubt. If somehow, like, if someone is going to further proceed as a career in a mediation, is it compulsory, like you say, to know the domain of the law? Being a law graduate, you have some kind of experience. So it's compulsory to go and absorb the court proceedings, to know how the court further proceed with the cases, to know or go further in the process of mediation.
See, Manya, as I said, earlier, the mandatory part is that you need to be a law graduate. And of course, when you go to the court and you work for some time, you get a perspective of law, right? Even as a lawyer, it's one thing to study law in books. It's another thing when you start going to court, when you see how law is to be interpreted, how in a given situation you need to answer the question of the judge, how the judge is interpreting the law. There are judgments of the court on certain, legal issues, right? Now, all those things you can't, you don't get to know when you're studying law. All that experience you only get when you're, going to courts and you're arguing either a matter or assisting somebody in arguing a matter. Then you get to know that, okay, this is the law which has been settled on a certain point, on a certain legal issue. This is how the Honorable Supreme Court has dealt with the matter. Now, if there's a matrimonial matter or like say a domestic violence matter, there is, there is a judgment which lays down the entire guidelines of this laid down by the Supreme Court. Now, if you're going as a mediator and if you're sitting in a matter where, there is issue of domestic violence between two parties and you're not aware of that judgment, right? Will you be able to facilitate and guide in the most appropriate manner? Right. So the purpose is that you are able to follow the process in the most fruitful manner, so that even if the matter is not settled, the parties at least go back from there with a certain sense of satisfaction that, okay, we at least tried and make an attempt, but at this stage the options couldn't be worked out. So you should be fully equipped. The mediator has to be fully equipped to assist the parties. Let me put it that way.
So like it's important to undergo with some of the court experiences to
Yes.
before proceed with as a mediator.
Yes.
Like we have one more question in the chat box. Okay. Someone, Aprajita, has written, as mediation process is not binding, what is the nature of mediation?
But why is it not binding?
She has asked.
I mean, as I just said,
Yeah.
that it is binding.
Yes. Aprajita, are you
Prajita,
there?
the mediation process is very much binding on the parties. As I just conveyed, once the parties agree to certain terms and conditions, and once those terms and conditions are put down on paper and signed by the parties and their counsels, right? You don't necessarily need a lawyer, but to understand certain legal aspects of the matter, as I told you, in a property matter or in a say a contractual matter, if there is a legal aspect, your lawyer could help you better. But yes, it is not necessary to take a lawyer with you in a mediation. But once the parties sign the settlement agreement, whether in a court annexed mediation or in a pre-conciliation mediation is when, before going to the court, the parties make an application to the mediation center to request that please make an attempt to settle our matter through mediation, where the parties have not yet gone to the court, right? And parties settle the dispute through a settlement agreement. That is also binding on the parties. The parties cannot wriggle out of it. It is binding in court of law.
Prajita, you may unmute your mic to answer if you have any further query related to your question.
No, ma'am. Thank you so much.
Everyone, if you have any questions related to any doubt you have related to mediation, you may ask ma'am. And I request everyone to fill the feedback form which has been in the chat box.
Hello, ma'am. Ma'am, my second question is how mediation is different from arbitration. they seem like a same procedure, but it is a bit different from each other. So how it is different? Can you like explain?
How do you think it's same? In what way do you think it's the same, Aprajita?
Like both are the methods of alternate dispute resolution. So
Okay.
both requires a person who is not who is fair.
Okay,
So
I'll tell you the difference, Aprajita. See, arbitration, yes, it's a method of alternate dispute resolution, because in certain matters where the parties so agree that in case of dispute, we will refer the matter to arbitration. There, an arbitrator is appointed as per the terms of the agreement between the parties. And the arbitrator decides and adjudicates upon the dispute, right? Whereas in mediation, the mediator is not deciding. If the parties, despite all the efforts made, despite facilitating and helping the parties to negotiate, if the parties are not agreeable to arrive to a mutual solution, the matter is referred back to the court. So the fundamental difference is that arbitration, though it's an alternative dispute, it's an alternative to the court process. But again, it's an adjudicatory process. The arbitrator decides and the mediator only facilitates. The mediator doesn't decide. I hope your query is answered. Aprajita,
yes, ma'am.
you've got the difference between the two?
Yes, ma'am.
Excuse me, ma'am. May I ask some question? One question, actually.
You're trying to say something, your voice is very low.
Ma'am, my question is actually I go through some of the documents, and in that actually, sir, there are some few points where they are saying that conciliation and mediation are same, and where there is saying conciliation and mediation are different, and we have to go through it through the Arbitration and Conciliation Act. So, is there any difference between conciliation and mediation?
Yes.
Though Mediation Act is right now in Rajya Sabha, so if you have-
Yes, there is a difference between mediation and conciliation also. See, as I just told you, Shreya, that in mediation, the role of a mediator is very, very facilitative. The mediator cannot even advise the parties, right? Though in India, when the parties come to us, there are parties from all, all categories of people come, and there are parties who say, "जी आप बताइए क्या करें इसमें, ठीक है ना, हमें तो समझ नहीं आ रहा, आप बताइए क्या करें." Now, as a mediator, we cannot advise. We have to tell the parties that you please go to your lawyer or seek some legal advice to ask them that these are the options before you. On the legality of those options, we can help them between options, but we cannot advise that, look, go and do this, your work will be done. Right? Now, as opposed to that, in a conciliation is when the matter comes to a mediator before it has gone to court. And the parties directly make an application and say that refer our disputes to a conciliator. Now, in conciliation, there is a little larger scope for the mediator or the conciliator to not exactly advise or guide, but can somewhere facilitate to a larger extent. If the parties ask something that, ma'am, now I have two options before me. On one hand, this person is ready to give me, say from, he initially agreed to give me 35 lakhs as alimony. Now he is giving me only 30 lakhs. But I have a life ahead of me and I'm a young girl and I want to carry on with my life. I mean, I don't want to get stuck into the dispute. what should I do, ma'am? Right now, as a mediator, as I said, the limitations are there, but as a conciliator, you will be able to guide them a little more. That what is important for you, not as a counselor, but as a conciliator. That what is more important for you. That you are a young person, you have a life ahead of you. You can do much more than that. It may be an amount of 5 lakhs. I'm just giving you an example so that you understand. Right? It's just, it's just, yes, 5 lakhs less. He's maybe acting unfair on the face of it. But then either you fight for this 5 lakhs or see your entire life ahead. Right? So this is a little step ahead in which the mediator can go in only conciliation proceedings. But as a mediator, you need to be very, very clear that no advice is to be given to any party. No judgments that, oh, you're acting unfairly. No, you're acting wrong. You are the one who has, wronged the other side or taken the money. Sorry, nothing. Got it?
Yes, ma'am. Thank you.
Ma'am,
Yes, Manya. Anybody else or we?
Yes, one more question.
Yeah.
Like there are many universities, open universities, which are now providing various courses under ADR.
Hmm.
So is it beneficial to have those courses? Like they are 1-year program?
See, Manya, I can't comment on the 1-year programs which universities are having. I mean, they may be good or not, but unless you, talk about something specific. But you need to see that the people who are doing actual mediations every day in court, right? Like, all 5 days of the day, I think I have 1 or 2 mediations every day. So when I'm doing, again, it's the question of experience which comes in. When I'm doing actual mediations, those people will be able to give you the training in a very practical manner, right? Instead of just theoretical, that you do this, you do this. Now, what are the situations in which you ask the right questions? How to communicate? How to turn, a negative feeling, a negative, moment of a person into something neutral, if not positive, right? So there are a lot of these nuances of mediation which can only be shared by you with somebody who is actually doing trainings, whether it's any university or, like I said, an organization or, high court. Of course, the high courts are continuously doing trainings. So it has to be with that experience, because unless you have that experience, you won't get the perspective of it.
Okay. Like Nalsar is there, the university, open university in law, which are providing the courses. So I have the one curious question, right? So I just asked that. Whether it's been good to do particular 1-year diploma course in the particular ADR, like in matrimonial ADR or in any other what civil, commercial it is. Like being having a theoretical knowledge, being in a doing in a 5 years of law, you have the same knowledge of a little bit of law, but it's a important, or it is like on us only totally. That's
No,
whether we
see,
should take.
this experience, you, as much as you get, it's good for you. Don't worry. This studying and getting experience never goes waste.
Yeah, thanks a lot, ma'am. And I request everyone to please put your camera on for a picture. Yes, everyone, if possible, somehow. Okay, I really thank you, ma'am, and thank you, everyone. Thank you so much, ma'am, for having us such a really insights on this topic particularly. Thank you, ma'am. Thank you, everyone, for joining us. I request everyone to fill the particular feedback form which is in the chat box.
Okay, thank you, Manya.
Thank you so much, ma'am. Good evening, ma'am.